Wonderful. Well, thank you everyone for joining our last webinar of the day. My name is Lindsay Robinson and I am the Executive Director of the California Cannabis Industry Association. We are really excited to have all of you with us today. This is our first series of webinars that we've been doing, and so far so good. We're really excited to be able to present in this format and to have our distinguished guests joining us to talk a little bit more about the emergency regulations for the cannabis industry. So thank you so much, Richard Parrott, Director of Cal Cannabis, for joining us. We're very excited to dig into your PowerPoint presentation. Just a couple of items before we get started. Everyone who is joining the presentation will be on mute. If you do have questions, please feel free to use the question option in the GoToWebinar control panel. Feel free to submit questions throughout. We'll try to get to all of them towards the end of the session. We have about an hour with Richard, so hopefully we'll be able to get through a lot of those questions. If we're not able to get through the questions, all of this information will be given over to Cal Cannabis and the CDFA so that they can make sure to get in touch with people. We'll also be providing them with the email addresses of anyone who submits a question. So it's a great opportunity to filter info directly over to Richard and his team. Thank you so much for 9 Point Strategies for helping us put this webinar together. We would not have been able to do it without you all. We really appreciate you coming into the office and helping us put all of this together. Big thanks to the CCIA staff, Josh Drayton, our Director of Communication and Outreach, for helping to coordinate all of this, and Justin McCarthy for also providing some technical support. So, without further ado, let's get into it. Again, we're going to go through the PowerPoint presentation. This webinar will be uploaded to the CCIA website and will be available in just a couple days if you want to come back and review anything. And I do believe after our panel that we participated on this past Sunday at the Emerald Triangle, that PowerPoints from all of the agencies are going to be available on their websites as well, because I know we are going to get some requests for that. So, all right, without further ado, Richard, okay. Thank you.
Well, thank you, Lindsay and CCIA for having me here. I'm Richard Parrott with the California Department of Food and Agriculture, and I'm the Director of the Cal Cannabis Cultivation Licensing Division. So I'm going to give an overview of our emergency regulations and a brief program update today, and then, as you mentioned at the end, we'll take, I can answer questions. So do we, how do we?
Yeah, take it away. We have a little, oh yeah, that, okay. Yep.
Excellent, okay.
Yeah. I think it might have to go down on the,
okay.
Yeah. So there you go.
Okay.
Perfect.
So I thought I would start out with just explaining who does what and the whole makeup of regulations for the cannabis industry in California. There's a lot of, tends to be a lot of confusion about which agencies do what in with regard to cannabis. In other states, it's typically one regulatory agency. In California, we have 3 who are licensing and regulating. So this just gives an overview of who does what. We are the California Department of Food and Agriculture, or we are the Cal Cannabis Cultivation Licensing Division. We also have California Department of Public Health, and they have the Manufactured Cannabis Safety Branch. And then under the California Department of Consumer Affairs, we have the Bureau of Cannabis Control. And if you look at the chart down below, it kind of goes in order of how cannabis works its way through the distribution chain, starting with cultivation, going on to manufacturing, distribution, testing, retail, and then we also touch on micro businesses. And you can see Cal Cannabis, we will be regulating cultivation. Manufactured Cannabis Safety Branch handles the manufacturing, and then the Bureau handles all of the rest of the activities within that distribution chain.
Oh, I think you might have to click on there. Hey Ryan, we're having just a little trouble advancing the slides.
There we go.
Oh, that was back. Does that one work better?
Okay.
Okay.
Perfect. Thank you.
Yes.
All right. Sorry, technically challenged. Here we go. So,
we got it. We got it.
Just a quick history on the regulations. We had originally, when we had the medical MCRSA earlier in 2017, the CDFA had issued draft medicinal regulations, and then in June, when SB 94 was passed, the trailer bill, and it repealed the repealed MCRSA and amended Prop 64 and created the Medicinal and Adult Use Cannabis Regulation and Safety Act. When that was adopted, we had to ultimately withdraw the proposed medicinal regulations so that a comprehensive set of regulations that covered both medicinal and adult use could be released by our agency. So between June and November, we analyzed the proposed medicinal regulations, what we could use from those. We looked at the input that came from stakeholders to help us craft the emergency regulations. On November 16th, we released those emergency regulations. November 17th, they were posted by OAL, and November 27th, they were submitted to OAL, and there was a brief comment period for emergency regulations, and that closed on December 4th. So for our cannabis cultivation regulations, this just shows the articles. I liken these like chapters of a book. This is how they're organized. It just shows you how we have them put together, starting with definitions and then what needs to be on the application, what licensing is all about, what site-specific requirements cultivators need to meet. Then we talk about record keeping in our track and trace system, and then inspections and enforcement. So this is just an overview of how the regulations are organized. Some key definitions that we'll hear throughout our regulations, and when you're talking about cultivation, is canopy, indoor, outdoor, and mixed light. So in our regulations, canopy is the area where mature plants will be. And there's a little more specifics to the definition of canopy, so I would encourage our viewers to review that. Our definitions are found in section 8000 of our regulations, and they can look at the full definition of canopy. Indoor cultivation is cultivation inside a permanent structure using purely artificial light, and we have a little bit more detail on that definition. Outdoor cultivation is obviously outdoor with no use of artificial light whatsoever, and then mixed light cultivation is inside a greenhouse or a hoop house or hot house using either mixed light and or light deprivation. And then for mixed light, we have two tiers, and it's based on the total wattage of the lights that are being used. The regulations delineate that and spell that out in very good detail. So these are our license categories, and we just talked about indoor, outdoor, mixed light. So if you go across this little chart on the top, it shows the type of cultivation that could be used, and then down the left side are the categories of licenses that we'll be issuing, starting from specialty cottage all the way down to a new license type that's for processor, and I'll talk about that in a few minutes. Within this chart, it shows the what's allowed for each license. Either when you're talking about specialty cottage for outdoor, it's up to 25 mature plants, and then when you look at indoor and mixed light, it's based on total square footage. Once again, this is square footage of canopy. Going down the chart, if you look at the medium license type, it does say it's limited. MCRSA, or the Act, required CDFA to place a limit on the medium licenses that can be issued. So medium licenses are limited to one license per licensee, either type A for adult use or M for medicinal. And all of these licenses are going to be issued as either type A or type M. If you look, the large licenses are not issued until January 1st, 2023. That was prescribed by the law. We also issue nursery licenses. Nursery licenses are part of our cultivation licenses. And then finally, the processor license down at the bottom. The Act gave CDFA the authority to create new license types, and processor was not a license type that was prescribed in statute, but it was created through our emergency regulations. And it's very clear what a processor can do. They can conduct only trimming, drying, curing, grading, or packaging of cannabis and non-manufactured cannabis products. So I want to talk about temporary licenses a little bit. In an effort through the trailer bill, the SB 94 created the ability to have temporary licenses. This was in an effort to help bring the existing industry into a regulated market, and has a few requirements that need to be met in order to apply for a temporary license. It's not as robust of a set of requirements as for the annual licenses, and this was intended to basically allow business to continue as it has been and kind of get people introduced to licensing as they apply for annual licenses. So just some specifics on temporary licenses. They are good for 120 days, and they may be extended for additional 90-day periods. The catch there is that in order to qualify for an extension, the applicant needs to have submitted a complete annual application to the CDFA. There's no charge for the temporary licenses. They're free. There's no application fee for those as well. And then the statutory provisions for temporary licenses, as they sunset on January 1st, 2019. Okay.
Great.
So for annual licenses, they will be valid for 1 year, and it's actually 12 months from the date that they're issued. They're required to be renewed annually, and we do have non-refundable application fees and also a license fee and an annual fee that apply for the annual licenses. When a person, I'm sorry, can I go back to the previous slide?
Absolutely.
I am very sorry.
No
I
worries.
left out the thing that's in bold that's staring right at me. In order for an applicant what an applicant must have for the temporary license is they must have local authorization. They have to have a local permit license or other authorization. That will be the key thing that they need to submit with their application for the temporary, along with some other information, but they must have that local authorization. That was prescribed in statute.
Okay.
Okay. So to the annual licenses, for local authorization, proof of local authorization is not mandatory for the annual license. An applicant may provide that. Whether they do or don't, we will still be notifying the local jurisdictions when we have an applicant apply. And I'll touch on that in a few minutes too. Annual licensees will be also required to use the California Cannabis Track and Trace System, or the Track and Trace System, and I'll talk about that in a little more detail. Temporary licensees won't be using the Track and Trace System. They will be moving product as it is sold throughout the distribution chain. Each licensee will be required to provide a paper invoice, receipt, invoice, and manifest to the person that the product is being sold to, and all of the licensing agencies' regulations clearly specify what needs to be on those paper invoices for that temporary licensee. So the annual licenses are all required to be renewed annually. So to touch more on the local authorization, the applicant may but doesn't have to provide local proof of local license, permit, or other type of authorization, but regardless we'll notify the local jurisdictions, because we part of the provision in the law is that the state will not issue a license if the applicant is in violation of a local ordinance or regulation. So we will be notifying local jurisdictions for instances where the applicant voluntarily provides proof. We'll notify the local jurisdictions, and they'll have 10 calendar days to respond to our agency if there are any issues. In the event that an applicant doesn't voluntarily provide it, and we notify the locals, they have 60 days in that instance to respond to us if there are any issues.
So would you suggest that people submit that local authorization to begin with, if they can?
You know, I think if an applicant has it, it will definitely make the processing of their application a little bit easier. So I think if they have the local authorization, I think they should definitely provide it.
Okay.
They must for the temporary, but if they have it for the annual, I would encourage. So I mentioned non-refundable license application fees. So I think the other agencies have a flat application fee. Ours are scaled based on the estimated annual production of the various license types. We worked with an economist to structure both our application fees and our license fee. So the fees are based on current known program costs for CDFA. The fees can only cover the cost of CDFA's program, meaning the fees aren't intended to generate any type of revenue for the agency. They are strictly to cover our costs of operating the licensing, compliance, and enforcement program. So you can see that on the low end, we have specialty caught at $135 for the application fee, and it goes to $8,655 for the medium indoor. So that's just a picture of our application fees. Those are prescribed in our regulations as well.
Mm-hmm.
So in this is the annual license fees. So in addition to the application fee for the annual license, the applicant will be required to pay this annual license fee and then pay it again upon renewal. Same thing here. The fees are based on current known program costs and also based on average estimated production of the various license types. The one thing I would also say too is that the application fee needs to be paid when the applicant applies for a license. The license fee, the applicant will be required to pay that when we approve their application and tell them that their application's been approved. Meaning, if they don't qualify and they're not approved, they won't be required to pay that license fee. It's only once we tell them that they're approved. We also will be conducting criminal background checks for applicants for the annual license. Anyone with a criminal background may apply. They will be required to submit live scan fingerprints that will go, and those are required for each owner. And criminal convictions that are substantially related may prevent the issuance of a license unless the applicant provides sufficient evidence of rehabilitation. And those, we have provisions in our regulations as well as in the statute that talk about the criminal convictions and what may be substantially related. So they can, if there are questions, we can have people look at our regulations as well. This is one I always just like to remind everyone for site requirements. It's very clear in the law. No alcohol or tobacco sales are allowed on the premises where someone is licensed for commercial cannabis activity. Just want to remind everyone of that. Mm-hmm. So we will have two different options for our application. We will have an online application system where people can apply right online and submit their the information that CDFA needs. They'll also be able to attach any documents that they'll need to provide. We have, those are all spelled out in our regulations for the application. There's a list of documents that the applicant will need to provide. They'll be able to upload those in the online system and basically attach those to their application. And we'll also have paper applications available for people who are not able to use the online system. So when our online system is open and available, we will have the paper application out there as well. And that will be on the CDFA's website.
Okay, great.
So we'll have a compliance and enforcement branch. As we move into 2018, we have a few staff in our compliance and enforcement branch right now. We'll be adding positions further into 2018. We'll have field offices for our compliance and enforcement structured throughout the state. We're in the process of determining where we're going to place those offices. One of the unknowns is where our licensees will all be located, so we're looking at strategic locations throughout the state right now. Mm-hmm. We will be conducting inspections of licensed cultivation sites, so we will have inspectors going to the licensed cultivation sites to ensure that they're complying with the rules and regulations, the statutes, and meeting all of the requirements that a cultivator needs to meet. We'll also be collaborating with other government agencies on our inspections. We won't be able to cover the entire state. We're in conversations with local ag commissioners and local agencies on partnering up and trying to maximize resources that may be out in the field. And we've got a pilot project with a few of the local ag commissioners that we're going to be working on in 2018 to see if we can share some resources for inspections. So this is to let everyone know there's a lot of talk of, well, what if I have a license and there's suspected illegal activity near me? Local jurisdictions will have the authority to take enforcement actions against illegal grow sites. We have an 833 a complaint hotline that is out there. People will be able to call and provide information to CDFA, and we will be able to, based on the information, determine what needs to be done with that. If we need to refer matters to local jurisdictions, we will. We'll be taking any action that's under the purview of CDFA as necessary, and we'll be also referring complaints that come into us that need to be referred out. So 1833 weed tip. We just think that's an important number for people to know. So a little bit about the track and trace system. So I mentioned earlier that temporary licensees won't be using the track and trace system, but annual licensees will. So a couple key things to know here. When a person who has a temporary license applies for their annual license and they're notified by the licensing agency that their application has been received, then within 10 days of being notified of that, they'll need to sign up for state track and trace training. So the state does have a vendor. The company is called Franwell, and the system they use is Metric. Down at the bottom of this slide, we say what Metric stands for. Licensees will be seeing more and more of this CCTT metric. So CCTT stands for the California Cannabis Track and Trace, and then Metric is the name of the system. Licensees will be required to go to training to learn how to use this system. It's meant to track cannabis products from seed to sale, so from cultivation down to the retail market. It requires the use of what are called unique identifiers. Those will be attached to various, so those will be attached to cannabis plants when they are, each mature cannabis plant will be required to have a unique identifier attached to that plant. Prior to that, if let's say a cultivator has immature plants, they're allowed to keep a lot of up to 100 immature plants in a contiguous area. That lot will need to have its own unique identifier for that lot of plants. Each plant within the lot will also be required to have a label that matches that unique identifier. In the event that a cultivator lost, let's say some of those plants in the lot died, or for one reason or another, were not able to grow and progress, then that cultivator would need to identify the removal of that plant from the lot and track that. And at the time the plant becomes mature and is flowering, they'll need to attach an individual unique identifier to each plant that will be able to be tracked back to the unique identifier that designated that lot, so that everything can be tracked. And then as products move throughout the distribution chain and are packaged, the packages will have unique identifiers as well. So everything will be tracked all the way to the retail level. I'll talk a little bit more about our plan for training when we get to the end of the presentation. We've had people ask, what will people be able to look up for our licensees? What information will be available? We've had local jurisdictions ask, well, what if somebody brings a license to me? How will I be able to know that it's valid? So our online licensing system will have a public search feature, and this just shows some fields that will be that they'll be able to see when they search. So they'll be able to see a license number, the type of license, the legal business name for that license, the county where it's located, where the premises is located, and the type of license, as well as the status. We had some questions at a previous workshop that I spoke at, wanting to know if the licensing agencies would be able to have monthly lists of current licenses, and we said that we would be looking into that, just in case there's a question about that. We all said that we would look into that ability. It was a really good question and a good idea. So then this is just information about our website and our phone number. So we have a lot of information on our website. There it is. There is calcannabis.cdfa.ca.gov. We also have an 833 CalGrow number that people can call with questions, or they can email us, and there's our email address. We're very active on social media, Facebook, Instagram, and Twitter. So there's all of our information right there. People can also go to the cannabis portal. I didn't have that on this slide, but cannabis.ca.gov is kind of the central point. I know it's intended to be a one-stop shop. If people go to the cannabis portal they look at anything dealing with cultivation, it'll send them our way. And then I would also want to just talk about some outreach events that we've had going and our plans moving forward. So we've been throughout December, late November, and up through this week, we've been holding licensing training workshops. So these workshops have been intended to get people who are going to be applying for cultivation licenses to these workshops, and we're doing a high-level overview of what needs to be on the application. It's actually a presentation that I gave at Emerald Cup, and then we're giving them a walkthrough and a demonstration of the licensing program and able to answer questions for the cultivators about our licensing system. So the last one is tomorrow in Eureka.
Okay.
That'll be the 10th one. We did a series of 10 this month, so the last one's in Eureka. I believe it's filled. We had to take registration because we have a capacity. So we'll be doing more of these later in January of 2018. We don't have the dates and the locations yet, but we're planning that, so more information will be on our website. And then in January, our vendor for Track and Trace is going to be holding regional workshops, and these won't be the focus training, but there'll be regional workshops for cultivators, manufacturers, retailers, all of the licensees who are going to be using the Track and Trace system will be able to come to these workshops to learn about. It's going to introduce them to the Track and Trace system, show them at a high level what it's about, and get them with an introduction and understanding so that they're more prepared when they are scheduled for their more focused training, that they'll have a frame of reference when they come into that training. So we will have information on our website soon about those dates and locations, and I think we had a little bit of information at our booth at the Emerald Cup as well. So we'll have that on our website. And then we're working on some other information that we'll be able to get out to industry soon. That'll be on our website to give some more detailed information. We know there's a lot of questions out there, and so we're working on things sets of information that we think is pertinent for the industry. So I would say, for people to check our website frequently for updated information.
Great.
Okay, and I think that's the end of my slides.
We'll go back one, and then that way people can get in touch. Excellent. Yes. So if folks have questions, please feel free to use the GoToWebinar question option. We'll try to get through as many of these as we can. We got quite a few, so for any question that we're not able to get to, we will be sending that over to the agency along with the name and the email of the person who submitted it, so that way your department can get back to folks. And we know that a lot of these questions that are coming from folks are issues of clarity, and so I know that you all kind of been trying to incorporate some of that into your frequently asked questions, which is great. I know the other agencies are doing the same, so these questions are being looked at and hopefully answered. All right, well, let's dig into it. Am I not mute? Yeah, there we go. Okay. You get catching some feedback. Okay. All right. Well, we're going to continue on. So we've been getting some questions through our question option here on the GoToWebinar. Hopefully you answered it, but again, I just would love you to clarify if Track and Trace will be used during temporary licensing, and just talk a little bit more about that, and then also the training that has to happen. That's something that could only happen through your agency.
Correct.
Okay.
Right. So yeah, just to clarify, so temporary licensees won't be using the Track and Trace system. They will be required to issue paper receipts, invoices, and manifests when they sell that product. Each licensing agency's regulations spell out what needs to be on the receipt, invoice, or manifest. So I would say if there's a question about that, definitely refer to the regulations. They're very specific about what needs to be on that document. So the training, like I said, we'll have the regional workshops in January when the temporary licensee applies for their annual license, and then they're notified by the licensing agency that their application's has been received. They'll get a notification that says, and it'll give them the contact information for the vendor to, they'll have the information to tell them to contact, the contact information to schedule their training. That training, we will, we're looking at either having classroom training, or we may end up having also the option of a web-based training that's interactive, where they will get a type of certification at the end of the training to show that to be able to demonstrate that they've taken that training. And we'll be looking for evidence of that before we'll be able to issue those unique identifiers to the annual licensee.
Okay.
Yeah.
Great. Thank you. So if a cultivator is in an area where the municipality does not have regulations, you know, on January 1st, but maybe they move forward with regulations a couple months down the road, do people still need to apply for their temporary license? Can you talk a little bit about what that process is like?
Right. So for the temporary license, one of the things that that is required, that did come right out of statute, is the applicant, if they want to get a temporary license with the state, they need to provide us with a local permit, license, or other authorization. So other authorization is we have examples in our regulation. So it's regulation 8100 for CDFA.
Everybody should look it up.
Yep. So it's 8100 B6. And we say other authorization shall include a minimum or reference that clearly indicates the local jurisdiction intended to grant permission to the applicant entity to conduct commercial cannabis activity at the premises. So it's really a conversation for that applicant to have with their local jurisdiction on whether or not that local authority wants to give them some type of authorization that they can provide to the CDFA, and we'll be reviewing that when it comes in.
Okay, great, thank you. So can an individual hold multiple cultivation licenses and a nursery license?
I don't know that there's nothing that prevents that.
Okay.
Yes.
Great. And can you talk a little bit about the nursery process in general? If a plant starts indoors in a nursery and then moves to an outdoor facility, would that be considered a mixed light?
So their nurseries, we have a specific definition in the regulations, and I'll point to that too. It's in section 8000 of our regulations, and it's letter V. Nursery is a licensee that produces only clones, immature plants, seeds, and other agricultural products used specifically in the propagation and cultivation of cannabis. So a nursery has a very specific activity. Nurseries aren't selling mature plants. So if sounds like what you described, maybe, you know, a cultivator who has an area of immature plants and then moves them to an area where they become mature.
They go outdoor, yeah.
Right. So, but a nursery has a very specific activity that's spelled out in our regulations.
Great. So heading over to another set of questions right here. Regarding the one medium license limitation, does that mean either 1A or M, or can you have both on a medium cultivation?
So on medium cultivation, it's one medium license, either type A or M.
Okay, so not both.
Correct, it's one. And then just if I can back to the nursery
Mm-hmm.
question,
Yes.
The one thing I did want to say is there's no distinction with outdoor, indoor, mixed light for nursery. It's just the definition that I read from the regulation.
Okay, great. Hopefully that will be helpful.
Thanks.
Sure. Okay. So Another question we have on here, does the online portal for Cal Cannabis allow for a third-party consultant to fill out the application on behalf of a client, or does it need to be an owner?
I believe that our online system will allow someone to apply
Okay.
On behalf, but they'll need to provide information for the owners. Ownership information will be required to be provided, as well as financial interest holder information.
Mm-hmm.
When that application is being completed, there's something called a designated responsible party, and that's the person that the applicant will need to identify. And that designated responsible party will basically be the person who is going to be the main person for that licensee.
Mm-hmm.
So, and that has to be an owner.
Okay.
Yeah.
Great. And is the online system for the temporary applications up and running yet?
It is not. That's a good question. A question we get frequently.
Yes, I bet.
It is not. We have when we've been asked at these types of forums, we've said that our plan is to have our online system available mid to late December. That's still our plan. So I would say, people should check back on our website, but we are working very diligently to have that available. Yes.
Good.
Yes.
Yes, I'm sure that is a big question. So
Yes.
folks should keep up to date and your listserv as well.
Yes. Oh, yeah. I'm sorry, I forgot to mention on our the website on calcannabis.cdfa.ca.gov. People can sign up for our listserv there, and we will what we call e-blast. We will send information out to everyone who signed up on the listserv. Okay. So, for instance, when our online licensing system becomes available, the agency will issue a news release or a press release, and then also we will send it out on our listserv so people will get notified.
Great. We've had some questions about commercial cultivators and doing pre-rolls and packaging. Do they also, can they do this activity under a cultivation license, or do they also need to have a different license type in order to do the pre-roll?
That's a good question.
Yes, it is.
So if it's pre-rolls, that is defined in our regulations as a non-manufactured cannabis product,
okay.
Which means they would not, if we're talking strictly pre-rolls, that's defined as non-manufactured cannabis product, so a cultivation license would allow that licensee to make pre-rolls.
Okay.
Okay.
I hope everybody heard that, because we got several of those questions.
You know what I would point to is once again in our definitions, in section 8,000, letter U, we define non-manufactured cannabis products, and we say it means flower, shake, keef, leaf, and pre-rolls.
Mm-hmm.
And then when you go to section 8,000 Z, we state that pre-roll means a non-manufactured cannabis product rolled in paper. Okay. So it's very clear in there that it's not a manufactured product, therefore it doesn't need a manufacturer's license to do with the cultivation license.
Great. We've also been getting some questions on micro businesses, and I know that micro businesses are permitted and regulated through the BCC, but in terms of the cultivation piece, do folks need to submit a separate application for the cultivation piece? Is it all going to be routed through the BCC? Are you going to regulate that portion of it and work with them? How does that look?
Yeah, so what will happen is they will be applying with for a micro business license to the BCC. We will be working with the Bureau for the portion of the application that pertains to cultivation, since that is, it falls within CDFA's area of expertise. We'll be working with the Bureau to ensure that that applicant is meeting all of the requirements. There's specifics. It has to be it's a less than 10,000 square foot cultivation under the micro business license. So they will need to meet the requirements for that type of license, those provisions, and that will be on that portion of the application. We'll be working with the Bureau. Ultimately, the Bureau would be issuing the micro business license, but it will be we'll be working in cooperation with the Bureau.
Okay.
Yep.
Great. So we're getting some questions on testing requirements, which I know also go through the Bureau. Can you speak to the it looks like, is it the 50-pound per batch piece, or should we have them direct questions to the Bureau for that
Yeah, I would
piece?
say to direct it to the Bureau, just
Okay.
because that really is under their purview, and yeah, it's best answered by the Bureau.
Okay.
Yeah.
Great. Will cultivations require workers' comp, and what type of insurance might be required for a cultivator?
I don't know that. I mean, it is a good question, but that's not a requirement or specified in our regulations.
Okay.
So I would say that would be something that we would have cultivators. Yeah, it's just not under purview, but I know they have to comply with all laws, California laws. They would, yeah.
Okay.
Yeah.
Yeah, I would imagine that all of the agencies are getting questions about insurance and things like this, so we might see some of those in the frequently asked questions.
Right, yeah, and I don't know if that's an EDD question or
Yeah,
Department
it
of
probably
Insurance, but it
is.
might be an EDD question if we're talking about workers' comp or
Yeah.
employment insurance or things like that. So.
We have a very robust insurance committee, so
Yeah.
we will tap them for some
Okay.
information on this. So, couple other questions that we have here. So can cultivators process their own product, meaning trim, oil? I know we talked about the pre-roll, but it seems like there might be a little clarity needed around some of that other stuff as well.
Right, so cultivators can process their own product. They wouldn't need a separate process or a license.
Okay. Great. With the limit for the one medium license type, is the limit per person or per applicant? I'm not sure what the difference might be there.
It's person. Yeah, it's per person.
Okay. Great. And then how will the conflict between the 1 acre cap in the ERA and the no acreage cap in the regs be resolved, if it needs to be resolved?
Well, our regulations are the driving, the regulations and statute are the driving, carry the force of law. So, and in our regulations, there is no provision for a cumulative limit on canopy. The limitation is on the medium license that we talked about.
Mm-hmm.
So ultimately, the regulations and statute are what carry the force of law.
Okay, great. And then the large comes online in 2020.
January 1st, 2023,
okay.
Large licenses become available or no longer prohibited by statute.
Okay, thank you.
Mm-hmm.
If a licensee holds both A and M licenses, does each plant need to be designated A or M from the beginning, like seed or clone, or is that something that would be separated during that mature, once it's designated as a mature plant, if it goes to in one direction or another? we're getting technical here.
Yeah.
This is good. Keep those questions coming.
And they do need to be. So the track and trace system is tracked by license,
Mm-hmm.
right? And so if you have an A license and you have A products, right, and you have an M license and M product. When I was talking about your lots, let's say of immature plants, you're going to be tagging that with a unique identifier that relates to that license type.
Mm-hmm.
Which, so if it's A, then those are going to be a lot of up to 100 immature A plants. So it is from the beginning.
It is from the beginning. Okay, that's great information. Thank you. So I guess this kind of pertains, but if you have both licenses and you have to keep inventory separate as it grows, which seems like plant, would there have to be some division within an indoor grow facility in terms of the A and the M?
Well, I think each license, so you have to have a premises for each license. You can
Okay.
So they can be co-locate, but they have to be separate and distinct.
Okay. Great, thank you. Can we talk a little bit more about the distinct premise piece and the co-location and how the cultivation emergency regulations are looking at what defines a premises?
So we, as part of the application, the annual application process, the applicant will need to provide us with a property diagram
Mm-hmm.
which is like a general overview of the property, and then within their cultivation plan, they'll be required to provide us with a premises diagram, which is more specific, and it shows the premises of where the commercial cannabis activity is going to occur, and that's very detailed, and they'll need to be able to delineate the canopy, and then also show, for instance, where their hazardous or where their cannabis waste may be taken. They'll need to show where any pesticides may be stored. So it's in that premises diagram they have to really specify and delineate everything out.
Okay, great. And speaking of waste management, can you talk a little bit about how waste on a cultivation site needs to be dealt with?
In great detail. I would just refer everyone to our regulation on that. If you allow me a minute, I can reference that number.
I know they're actually digging into the emergency regulations right now, so we can get these questions answered.
So it is in section 8108. We talk about cannabis waste, and I would say to have our audience read that.
Okay. Great, and we'll make all of this information available for sure in multiple forms. So again, this webinar is going to be posted on the CCIA website in just a couple days, so folks can refer back. But if you have any specific questions, you can certainly reach out to the cannabis department, and they'll make sure that they get you the information you need. So this might not pertain to you. This might be more of a BCC question, but will dispensaries be able to package flower, A, themselves, and B, are there opportunities for a cultivator to go directly to a retailer without having distribution in the middle?
Yeah, those are, since the Bureau licenses and regulates both distribution and retail, I would say that's best answered by the Bureau.
Okay.
I've sat with Ms. Ajax on enough panels. I've heard what she said, but I would say that they should ask the Bureau those questions. Okay,
great. And if folks are looking to do a deep dive into the emergency regulations, where can those be found?
So the emergency regulations are on our website and also on OAL, on the Office of Administrative Law's website.
Great.
And they can do a deep dive and read through. Ours are, I think, ours are about 63 pages.
Yes, yeah. Yes, they are. Okay, so we have gotten quite a few questions, and I know we talked about this a bit on the panel at the Emerald Cup this past weekend. Felony convictions for cultivation or distribution. How are those going to be dealt with?
So those are going to be reviewed by our agency, and we talked about how there can be those certain convictions. They can provide proof of rehabilitation. So it's really going to be on a case-by-case basis as we get the applications and review them.
So if someone does have a felony conviction, are you encouraging them to still apply for a temporary license if they're able to?
I would say everyone's able to apply for a license, and then it will be subject to review.
That was Lori's general sentiment. She's like, just get the licenses, just get the applications in there.
Yeah, everyone can apply it, and then it'll be reviewed. And if there are questions or any type of issues, we will be contacting the applicant and notifying them and working with them on any information we need.
Okay.
Yeah.
Great. Thank you. So from your perspective, from the kind of cultivation side, where do you anticipate that we might be seeing some choke points in the supply chain, if any?
In the supply chain, I don't know. I think that the way the regulations are rolling out with temporary licensing and then having that 120-day period with the options to extend the license allow for a transition into this regulated market, and also the fact that applicants will have the ability to take the track and trace training as they're getting their annual license, also allows for another transition period into this regulated market. So it doesn't it doesn't, what we have in front of us, there aren't things that would put an immediate stop to commerce happening.
Mm-hmm.
So I'm always an optimist. I think that I would say, the applicants apply for the temporary license, and then as they have their temporary, then they get the information. They should be getting the information together now for the annual license, because our regulations spell out what they need and have it ready to go. And then, just be diligent about taking that track and trace training when they're notified, so that they are meeting any of the deadlines that they need to meet of requirements they need to meet to get that annual license. It'll help for a smooth transition.
Great. And you might have mentioned this piece before, but in terms of the training for Metric, do you anticipate that it's going to be a 4-hour training, a 6-hour training, a 2-week training?
I know that it'll be done. The goal is to be able to have it done in a day. I think the regional workshops in January might be a couple hours, and I think the training might be around 3.
Okay.
Because it is a web-based system, and it requires some bit of a deep dive into understanding the system. And then also, I know that we will have refresher videos and YouTube videos that will be available for licensees once they've had the training, and in case they want to go back and check on something. And then we'll also have a place where they can call if they have questions.
Okay.
Yeah.
Great. And this might be a trick question, but do temporary licenses need to use the track and trace system?
Is that a trick question?
Just to make sure.
I
do keep hitting it. So I think that piece is a little bit overwhelming for some folks. So I'd love for you to touch on that again.
So temporary licensees won't be using the track and trace system. The regulations talk about what needs to be put on a receipt, invoice, manifest that they would be using to move that product forward throughout the distribution chain. And the reason why we did it this way is because we need them to have the training in order to use a track and trace system. And with the timing with regulations coming out, and with January 1st, 2018 being the date that everything goes live, everything would have basically come to a stop if people needed to wait to get their training. And we know that temporary licensing provisions were put in there to allow the market to continue as people come into compliance. And so that's why temporary licensees aren't using track and trace. We don't want the market to come to a grinding halt.
Yeah. No, that would make it really difficult for folks to become compliant, which I know is the goal of all of the agencies, is to be able to help foster that movement. Yeah, great. So in terms of the annual inspections that will have to happen, they would probably differ a little bit, I'm sure, with outdoor grows rather than indoor grows. Is there some coordination going to be made with local fire departments, the way that you need a fire department to come in and inspect a manufacturing facility in order to get the permit? Are you envisioning something similar?
As far as a coordinated effort for inspections?
Yeah, or what do you have an idea of what those inspections might look like?
We are, we're part of, we're very active in various task forces that are out there with local law enforcement, also with the Bureau and other agencies. One of the things that we want to avoid where we can is what we would call they call it audit fatigue, is having a licensee have a bunch of different people visit them at different times. So we are, as much as we can, going to try and coordinate efforts so that when we go out, it's as much as we can at one time, so that our licensees aren't being bombarded with inspections all the at different times. Yeah,
that's great. So we've gotten a few different questions about how do cultivators get their product to market? You could speak a little bit about that. And then do you think that there is an option for direct sales, like a farmer's market, for cultivators to be able to sell directly to consumers at some point?
Oh, at a farmer's market?
Yeah.
Those kind of teeter into the Bureau's purview. When we talk about our cultivation licenses don't allow for direct, obviously the only license type that can sell direct to the public is going to be a retailer. So it's really that's a question that's really for the Bureau.
Okay.
Yeah.
Okay. What are some of the most pressing questions that you all have been getting in terms of clarifying some of the regulations?
We've been asked about the definition of canopy.
Mm-hmm.
We've been asked about there were questions we had early on if the use of generators were going to be banned,
Mm-hmm.
and so in our regulations we have a clear definition of what canopy means. We talk about what can be used with as far as generators. So our regulations talk about that and kind of give the specifics. Those are the two biggest ones that jump out at me right now.
Great. Well, we are just about wrapping up. I think we've gotten through almost all of our questions. Last one that just came in here. Are cultivators required to package flower?
I believe that cultivators will be. I know that cultivators will be putting flower in packages.
But I don't think they're required.
I don't know if they are. That's a good question. So that's one where let me, if I can, research and
okay.
And
might be a good one for a frequently asked question, which I know all of the agencies are gathering all of this good feedback to.
If I can make a note of
that
one, then I'm going to. I'll make a note of that. And it was
are cultivators required to package flower? Also, too, all of these questions are going to be submitted directly over to the agency so that they can have that information and reach out directly to folks if some of this stuff has gone unanswered. But that basically brings us to our wrapping up point. I really appreciate everyone spending the last hour with us, and for all of your great questions. We'll make sure that they get over to the agency. I really want to thank Richard for coming in. And thanks for
not being too hard on me with the questions.
Yeah, no, I got really good questions coming from the audience. So and I know that everyone really appreciates you coming and sharing all this.
We could be here and help out. We want to, as much as we can, get information out to everyone so that it makes it easier for them to understand the laws and regulations and comply. So thanks for having us here.
Absolutely. Our pleasure, for sure. Thanks again to 9 Point for helping put this webinar together. We couldn't have done it without you. And thanks to all of you for participating. Keep in touch.
Thanks.
Thank you.